something's weird. The instructions to these agents were very clear, it sounds like, but FBI agents disregarded those instructions. Jack said, well, any handwritten sheets that currently remain in the boxes do not represent additional classified documents. They were just not removed when the classified cover sheets when the index code were added. Wow, so they also shoved in a bunch of unnecessary documents that are not even useful. Jack said, well, any handwritten sheets that currently remain in the boxes do not represent additional classified documents. They were just not removed when the classified cover sheets when the index code were added. Wow, so they also shoved in a bunch of unnecessary documents that are not even useful. Donald Trump's defense now filing a motion to dismiss, saying that Jack Smith and the DOJ destroyed evidence. It's gone, and it's important evidence because it's exculpatory, which means it would show Trump and his co-defendants' innocence if it were around. And now the defense does not have access to it. They say the entire case should go bye-bye. They submitted this motion to dismiss in Judge Cannon's courtroom, and we know that previous motions to dismiss have been filed and already denied. It's very difficult for a motion to dismiss to be granted, but there are many attempts here, and these are all being etched into the record for an appeal. And you don't need all of them to be successful, you just need one of them. And this one is pretty shocking because it puts the defense at a serious disadvantage, one from which they cannot recover because the evidence is gone. It's been destroyed. President Donald Trump's motion to dismiss based on the spoliation of evidence in violation of due process. Evidence spoiled, destroyed, and not accessible. President Trump respectfully submits this motion to dismiss this indictment and to suppress all evidence that was coming about based on the raid of Mar-a-Lago. Why? Well, the FBI destroyed important exculpatory evidence relating to the locations of the allegedly classified documents at issue. Footnote 1. They say some time ago on May 31st, Trump sought leave to file this motion, and the timing is due to a series of untimely disclosures. Why are we filing this right now? Well, here's why. Jack Smith just dropped off a bunch of stuff lately of exculpatory information and discoverable evidence that began in early May. So, Your Honor, we're bringing this to your attention right now because they just dropped it on us. They had it this entire time, but they just gave it to us. Now, the prosecution team, they tell us, that's Jay Bratt, that's Jack Smith. They destroyed exculpatory evidence supporting one of the most basic defenses available to Trump in response to the politically motivated charges here. Jack has wrongfully alleged that Trump was aware of the content of the boxes. So Trump knew. He knew what was in them in August. He knew where those boxes were packed by others in the White House and when they were moved to Florida. So Trump was aware of what happened with them before they landed at Mar-a-Lago. Now, the fact that the allegedly classified documents were buried in boxes and commingled with Trump's personal effects from his first term strongly supported the defense argument that he lacked knowledge and culpable criminal intent with respect to the documents at issue. Any proximity between allegedly classified documents and other dated materials from years before the move, okay, so there were letters in there were newspapers, they would have further strengthened that argument. So you have a bunch of clippings, magazines, then classified. So the prosecution team's instructions to agents who executed the raid essentially acknowledged these propositions. So they said, yeah, it's true. If you find stuff like this, you got to hold it like in a sealed position. Don't taint the evidence. And directed agents to take care to document the location of both seized items and potentially privileged documents. But something's weird. The instructions to these agents were very clear, it sounds like, but FBI agents disregarded those instructions. The government was more interested in staging and leaking the manipulated photos, which we saw when they spread it out all over the place and put the classified cover photos on, than they were preserving the exculpatory evidence that's now been lost forever. So they just shook those boxes right on the ground. Now, the agents did not maintain the order of the documents. They did not take photographs that would have served as an alternative evidence of the documents and their sequence in each box. In July 2023, the agents disclosed this fact during a meeting with the prosecutors at Jack Smith's office. So they've known about this since July. And the Southern District of Florida was there. But the office did not timely disclose the notes from that meeting from almost a full year. They just gave them to him. Here you go. Oh, we manipulated the documents. Forgot to tell you. Indeed, they persisted in that suppression. They didn't tell us about it, notwithstanding that the notes were responsive to our discovery requests. We specifically asked about this, and they urged the court to rush to trial based on false assurances that they were in compliance with their discovery obligations. So in other words, Jack said, Your Honor, we're ready for trial. Trump said, no, we're not ready for trial. We haven't gotten any of our discovery materials that are in the possession of the government. We need this, and we need that. Jack said, we've already given you everything we have. There's nothing. Let's go to trial. There's nothing nothing else to disclose. Turns out, oops, there is. Just last month in May, they said, oh yeah, by the way, we messed up your documents. We shuffled them out of order so you can't reconstruct them. Well done. And they just told us, Judge. In hearings during March and April, Jack Smith's office even misrepresented to Judge Cannon that a pre-raid sequence of the documents was intact. Only after an evidence inspection by counsel for President Trump's co-defendants revealed the extent of the problem did the office disclose that the documents were not intact as they claimed previously. They manipulated them out of order. Vague language in that submission and corresponding additional discovery demands from President Trump caused these due process violations to further unravel. The Constitution required far more than Jack Smith's office and the FBI were willing to do. That is evident from the spoliation at issue here, as well as from separate pretrial motions seeking to compel other important discovery steps, suppress unlawfully seized evidence, remedy additional prosecutorial misconduct, and enforce the presidential immunity doctrine and the Appointments and the Appropriations Clause and dismiss the charges on the basis of selective and vindictive prosecution, suppress unlawfully seized evidence, and so on. Now, to date, the office's discovery obligations and ethical requirements have taken a back seat to President Biden's election interference mission. That must stop. For the reasons set forth below, the court should dismiss this indictment, suppress all of the evidence that came from the seizure of this raid, and conduct the fact-finding that's necessary. Let's hold some evidentiary hearings, baby. Let's get some witnesses in here. Bring them in here. So here's what the defense says. On August 8th, 2022, we remember that day vividly, the FBI carried out an unprecedented raid targeting the residence of Trump. Now, as the court is aware, the participants in this raid relied on a search warrant that's already the subject of a multifaceted motion to suppress because it was garbage. Now, prior to the raid, the government's investigative team designated a, quote, filter team that consisted of 3 attorneys. They brought in these knuckleheads, 1 from the DOJ National Security Division and 2 from the Southern District of Florida. They also brought in a squad supervisor and 4 special agents from the Miami field office. Now, this so-called filter team was responsible for the initial search and review of President Trump's office at the Mar-a-Lago 45 office, as well as the storage room referenced in the indictment. Thus, the filter team was just the tip of the spear for the government's raid, and as far as the defense can tell, they were the ones responsible for the initial search of every box, every desk drawer, and every other container at the office that the government unlawfully targeted, right? So it's this group of Trump raiders who are going to go in and just ransack, take photos of Melania's bedroom, Barron's bedroom, all the things. Then the rest of the team will come in. So prior to the raid, one of the filter team attorneys provided detailed instructions to the filter team. Says, hey guys, I'm your lawyer. Remember, when you go in there, this is how this is going to work. Now, the instructions included the following. We have a footnote 3 that tells us that the exhibits submitted in connection with this motion have been redacted in a manner consistent with your prior rulings, and so we've done that. Now, the instructions included the following. So they said, okay, when you raid the Mar-a-Lago residence, follow my instructions. The attorney's like freaked out. If during the search of 45 office, the filter team identifies a document marked as classified that is commingled in a container, so there's a magazine and a classified doc with potentially privileged materials, the filter team should document the location of the classified document, so where is it, photograph it, and the location where it was found, including with the commingled documents and the container. So it's not complicated. Take it, where is it? You're going to pull it out. It's classified. It's got national security in there. So you're going to pull it out, replace it with a placeholder. Let's take a bunch of photos of it, and then provide the classified document to the case team so that it can be handled appropriately, right? That makes sense. Okay. Put a placeholder in there. You isolate everything so stuff's not shifting around. You put some foam in there. You seal the whole thing. The instructions also directed the filter team to be mindful of the fact that photographs taken by the ERT, the evidence response team, of any responsive materials in the office, including the location where the materials were found and any other commingled materials, may also contain privileged material. So your photographs could be a problem too. So those are the instructions. Let's see what these brilliant FBI agents did. Now, according to the government's return associated with the raid, so here's what we did. This is what we seized. The FBI seized 39, quote, boxes and or sets of documents that contain commingled items that are described in the attachment. That's what they said they got. They got 6 additional boxes that also contained potentially privileged items that were also commingled. Okay, so they're saying commingled here. Now, the filter team was responsible for the initial review as well as the unseized items at Mar-a-Lago. However, as discussed in more detail, notwithstanding the foregoing instructions, they were told what to do, the filter team made little effort, if any, to document the location of the seized items within a box or to maintain the order of the documents within the box that they searched. So they just opened up your DoorDash order and they just shifted everything around. They took a couple bites of things and they shoved it back in there and they said, here's your evidence. The FBI transported the 45 seized boxes to DC on the morning of August 9th. So they didn't follow the instructions instructions that the lawyer told them to do. The reason the lawyer wrote those instructions is because that's the lawful way to do it, to preserve the evidence so the defense has an opportunity to review it. That afternoon, in an email that illustrates immediate concern about the filter team's failure to follow the instructions, the lawyer's like, wait, what? I put it in the document. Why aren't they listening to me? I feel you, bro. To follow the instructions regarding documenting the location of the seized items. An agent from the FBI's Washington field office sent an email asking one of the filter team agents to please call me ASAP. Exhibit 3, the Miami agent responded that another member of the filter team, quote, assisted me with what we discussed. It's too late. The other agent also has more updated information concerning where the documents were allegedly located. They're all trying to piece it back together again. Oh, crap. The relevant proceedings now are as follows. On August 22nd, President Trump initiated the Trump matter in the Southern District of New York to protect his rights. Then the government responded. So Trump said, how dare you raid me? Then Jay Bratt and others, the government, they responded. So Trump got raided. He filed, how dare you raid me? Then the government responded and they acknowledged the relevance of the location of the documents. So they said, oh yeah, they argued that the location of the passports the FBI seized was relevant evidence because it was about national defense information. They also argued that the commingling of personal documents with the classified documents is relevant evidence. So they said, okay, it's commingled, so it's important. And third, they also said it was reasonable for the agents to remove intact files in connection with the raid. So they admit that they did it. They admit that it's important whether they're commingled or not. And they admit that the location of certain items, like a passport, is relevant. So by their own admissions, all this stuff is critical. And they just messed it all up. This is good lawyering right here. Also, on August 30th, attorneys from the filter team filed a report with the court. Now, despite detailed discussions of search procedures, the report did not describe the pre-raid instructions to, quote, document the location of the seized evidence. Nor did the filter team's report disclose that the agents had failed to maintain the order of the documents as they rummaged through the boxes before they got to Melania's room. Much less that certain agents regarded the instructions they thought that they would have been impossible to comply with. So now they're backpedaling on this. Now, in October of 2022, in response to an order from the court and instructions from the special master, remember that entire saga? We had a special master who was appointed by Cannon, who was independently verifying that the DOJ was staying honest until she got overturned on that by the 11th Circuit. The government caused a third-party vendor in Virginia to scan unclassified documents seized from Mar-a-Lago. In September, an FBI agent called Agent 19 sent an email regarding planning for the project. The instruction included, quote, all classified placeholders must be removed from the boxes and replaced with generic spreadsheets at the appropriate level. So based on these disclosures, it appears that the FBI's handling of the classified placeholders may have even led to further reshuffling of the documents within those boxes. It also appears the FBI failed to document the scanning process until June 5th. So once the FBI even got their hands on it, they didn't handle it right at the first place. When the first sweep went through, they screwed it up. And then when the FBI got it back, they screwed it up again, which is just perfect because this is key evidence. So post-indictment interviews. Now, beginning on July 11th, after the indictment was filed, a member of Jack's office and an attorney met with FBI agents. They wanted to discuss the execution of the raid. Now, there were entries in the notes. So here are notes from their meetings. It says filter searches. Uh-oh, look at this. Ordered, not preserved. Filter material pulled to front, top of box for DC to explore. You see what happened? Filter at some point started pulling class out and placed on top. Search team still went through every doc. So you've moved those banker boxes around. So you have some feds. You probably see these like at the record stores too. When you go to the record, you're like flipping through the records. Oh man, Nirvana. Sweet, man. Oh yeah, cool. So you're flipping through these records. Oh, classified document. They pull it out. There's one. Set it right on top. Now the notes refer to the need for a follow-on call with two other agents, but that has never actually happened. Now, as discussed below, special counsel's office did not produce these notes to the defense. Oh man, you're kidding. Not until May 23rd, over 10 months after the meeting occurred. So that's a pretty important thing. Ordered, not preserved. Started, the filter team didn't follow the lawyer's instructions, started pulling classified documents out, placed those on top. So then after that, June 2023, Jack's office started to produce discovery. On September 1st, the office produced what they call their NARA box scans. We scanned all this stuff. Now, we understand that that is related to the so-called 15 boxes that Trump voluntarily disclosed to NARA. So he sent the boxes back, they scan them. On October 9th, President Trump asked Jack Smith's office to disclose, quote, all documents related to the execution of the search. They defined our documents to include this: notes, memorandum memoranda, reports, text messages, all the things. So in response to this request, so Trump said, we asked you for it. It's here in writing. Jack's office claimed, falsely lying, that it had already produced all the materials that Trump is entitled to. You already have it. Oh, you did. You gave us everything. You said that was in October 2023. Why are you just dropping this key evidence that was in your notes right now? Because you're trying to cover it up. Yeah, in connection with the response, the office disclosed the operations order that is central to their pending motion for a gag order and an additional FBI photo log, but not all FBI electronic communications regarding the execution of the search, not the instructions to the filter team, and not the notes from the July meeting. None of that was disclosed. And they say, and in which the filter team disclosed that they did not maintain the order. So we got no information. Now, at least twice, Jack's office also misrepresented to you, Judge Cannon, that the order of the documents were intact. Twice. He told you that, Judge. They said documents were in the same order now as they were at the time of the raid. During a conferral with Jack's office on June 6, a week ago, Trump's counsel asked the office whether the order of the documents in the 15 boxes is intact. We asked on June 6, are they intact now? As of this filing, they have not addressed that question. Oh my gosh, these people. Now, on March 1st, the court conducted a hearing about scheduling, and in connection with the time necessary for discovery, the lawyer Stanley Woodward for Mr. Nada asserted that he needed to sit with Nada to review the contents of the boxes, including the documents as they existed in the box at the time there. Now, Brat said, so he says, I want to go look at the boxes. I want to make sure they're in the exact order. So Brat responded, he said, wait a minute. The boxes have always been available for your review. That was in our first discovery letter to you guys, so you already have it. Now, Brat says, as I think I explained, the actual classified documents were pulled out and stored elsewhere, but there are markers as to where they're found. So it's been manipulated again. So on March 12th, counsel for Nada and De Oliveira reviewed the contents of the boxes. And when they were there during the inspection, the lawyers were advised misleadingly. Someone told them that as a result of the special master's review of the boxes, the contents may not be the same order as when they were seized. Wow, these pieces of garbage are now blaming the special master. No, we didn't screw it up. It wasn't the FBI or the DOJ. It wasn't Brat and those lunatics. It was the special master who screwed it up. In fact, the documents in the boxes are not in the same order as when they were seized, principally because the filter team made no effort to preserve the documents. So that's why they're messed up, not because of the special master. Now, on April 12th, this court held a hearing relating to the pretrial motions filed by the other co-defendants. Now, during this hearing, Brat made the following misrepresentation. He lied again. Court asks Brat, hey, Brat, stand up. Oh, sorry. Are the boxes in their original intact form as seized? Brat says they are, with one exception, and that is that the classified documents have been removed and placeholders have been put in the documents. Not true. Now, on May 1st, 2024, counsel for Nada joined a pending application for an adjournment, and counsel reiterated that the content of the boxes, including where documents with classified markings were within the boxes, is relevant to us. We need to see where they were. So let us come see the documents. Now, in a responsive filing on May 3rd, Jack Smith and Jay Brat disclosed for the first time, despite being on notice of this fact since July 11th of last year, they just told Trump's defense that the filter team, quote, from their words, not ours, was not focused on maintaining the sequence of the documents within each box during the raid. We didn't care about what order they were in. Who cares? Subsequent disclosures to the defense have revealed that the phrase not focused was at best a remarkable understatement. Yeah, they were not focused. You're right about that. That's true. Some filter team agents now claim that the task that they were instructed to perform was impossible. Like, no, we're not going to do that. Well, the lawyer said you had to. Well, we're not. Okay. So I guess that means you have no evidence because you've now tainted it. The special counsel's office also disclosed on May 3rd that the investigative team had removed and segregated from the boxes documents allegedly bearing classification markings, and they replaced those documents in the boxes with the cover sheets. But then in Washington, the FBI, quote, generally replaced the handwritten sheets with classified cover sheets annotated with an index code. So it remains unclear to an unacceptable extent what the office's generally qualifier was intended to mean. What is that generally? Did you do it or not? Well, we did generally. No. You either did or you didn't do it. So in an effort to explain why some handwritten cover sheets remain in the boxes, so okay, if that's how you're doing it, why are these still in here? Jack said, well, any handwritten sheets that currently remain in the boxes do not represent additional classified documents. They were just not removed when the classified cover sheets when the index code were added. Wow. So they also shoved in a bunch of unnecessary documents that are not even useful. We just didn't remove them. So, okay, now there's a bunch of additional stuff that you've tainted this with. The submission does not meet meaningfully engage with the importance of our email thread, that removal of all classified placeholders and generic spreadsheets and a generic marking system be replaced. So they can't even explain what their own policies are and how they're supposed to be comporting themselves. In a further strained effort to explain the current composition of these boxes, Jack Smith also said this. He said, in many but not all instances, the FBI, not all, was able to determine which document with classification markings correspond to a particular placeholder sheet. Did you hear that? Jack Smith wrote that. In many but not all instances, the FBI was able to determine which document with classification markings correspond to a particular placeholder. So you pull the classified document out. These are the nuclear codes. You put in another placeholder. It's supposed to reference the nuclear codes, but apparently they don't know. So now that placeholder, it could be the Fauci's biolab for all we know. Well, could be that, could be the nuclear codes to Saudi Arabia. We have no idea. And neither does the FBI. Isn't that outstanding? The office made no effort to specify what many but not all instances mean for which that statement was accurate, and we still do not know with specificity what that office meant. Now, Jack's office finally acknowledged, that there are some boxes where the order of the items within that box is not the same as the scans. So they then scanned them so that they had a record, and then the boxes shifted again. Based on subsequent discovery disclosures about the filter team's approach to the raid, including notes from their meeting, it appears that some boxes, with the prosecutors reference some of the boxes are problematic. What they meant was not some, they meant all. That's what they really meant. So the office also relegated to a footnote the additional troubling admission that the current situation, quote, is inconsistent with what the government counsel previously understood. Sorry, judge, we lied to you. If the judge asks you yes or no, and you do not know, the answer is I do not know. Did you give me everything? Yes, I did, Your Honor. And you didn't? Well, that's a problem because you said you did. The office offered several explanations, but they failed to disclose the most obvious. As the office had known since July 23, but had not disclosed, the filter team did not even try to preserve the orders of the boxes at all. Instead of making that clear, they just dragged this out. They speculated in a misleading fashion. They said, well, there were instances where the boxes were accessed after the raid, and the size and the scope may have possibly led to the movement of items. Okay. Notwithstanding, the source of the problem was them, the raid themselves, and they suggested to the court that the order of the documents really didn't matter. Now, in response to all this, Trump wanted additional discovery demands. They said, we want everything. Okay, we think this is a problem. Give us everything. We want everything about the execution of the raid, communications, chain of custody, FBI general policies, whatever they mean when they say generally. We asked the office to identify the boxes that they currently concede that are out of order. So tell us which ones those are. And after Trump sent those discovery demands, members of Jack's office interviewed the FBI. Now, it appears that the July 2023 meeting was conducted in a group setting. The office interviewed the agents individually in May. During one interview, a member of the filter team asserted that it was, quote, not practical to ensure that the documents' orders were maintained. Oh, not practical. Another agent claimed it would have been impossible to maintain the order. Not possible to maintain the exact order as when we first opened them. Similarly, FBI Agent 13 also indicated. He said it's impossible to maintain the exact order. And FBI 13 said that she or he did not focus on maintaining the order, nor she could, even if she was focused on it. There's like way too many documents for these feds. They can't handle all that stuff. It's like lots of papers. FBI Agent 13 also disclosed that she had pulled documents with the classification markings from their location within a box and placed those documents on the top. She's the one pulling it out. Agent 17 told Jack Smith that he can't say with 100% certainty that everything was in the same order. He also said that an unspecified set of notes relating to the raid was in his desk in Miami, and he didn't even upload those to the case file. Just a total free-for-all. Then they make late disclosures. On May 23rd, Jack's office responded to Trump's discovery demand. Although the disclosures are plainly relevant to the defense motion practice, they took the position that no, we don't owe you those materials. They included the following materials, which are all listed here. Tons of different reports that they want to get. They also say, so Jack Smith is trying to say, I'm responding to you. In his 15th production, they also suggested that they were uploading this stuff. But no, they were not giving this to us. And so finally, with very little explanation, Jack Smith has refused to provide the details that we're asking for. We keep demanding for this, answers on all this. They keep coming back with vague claims. In response to this other request, we asked what boxes. They did not tell us. You know which boxes are out of order, so tell us which one. The office did not disclose the steps that they had taken, and they're just refusing to do so. So, Your Honor, there's a bunch of applicable law here, and you should penalize Jack Smith with failure to preserve these materials. These are exculpatory evidence. They violated Trump's due process rights. They failed to keep these documents in order. And this is important material. It's exculpatory evidence. Dismissal is the only appropriate appropriate remedy when they destroy the evidence that we need to defend ourselves. As the government plotted to raid Mar-a-Lago, it was manifest that the location of the documents within each boxes, buried and commingled, would play a significant role, because for any charges, they would have to show that Trump was aware and that he had knowledge. Now, the temporal gap between the packing and the moving of the boxes to Florida by the third parties and the retention, all of this was important to them. That's why they put it in their search warrant, and they focused on the filter team. And now Jack Smith is withholding portions of the evidence and the material. Following the raid, Trump filed litigation. They knew that we wanted this stuff because they even admitted that commingled materials are important to know whether it's commingled or not. They acknowledged that it would require proof of Trump's knowledge that he knew about these materials. And so dismissal, now that we can't go to intent, is appropriate. Judge Deary also said it's bad faith, and they failed to preserve this useful evidence. They give us some case law. We do know that the boxes contained items like newspapers, letters, and dated long before Trump's first term in office ended. It would have been potentially useful and powerful in some instances for the defense to be able to use this proximity to show how long the alleged classified documents had been in those boxes. But due to the spoliation, however, there are no comparable means to present the most forceful articulation of this argument. And they did act in bad faith. A bunch of case law tells us what the standards are there. And we talk about animus. And since at least September of last year, Trump has called attention to Jack Smith's office. They are rushing to trial. They are recklessly pushing on behalf of Joe Biden. They're not complying with their discovery. They're not even following the Justice Manual. Now, all this is false. They make these allegations, but they're not. A lot of this stuff is being disputed. And had they actually reviewed this material, they would have produced these notes much sooner than they have. They're delaying, not giving us the materials that we asked for. If the case file had been reviewed as necessary, they would have produced these messages a lot more quickly. We can't just write off these untimely disclosures as just, oops, we just found it. No, they are delaying it on purpose. They keep using phrases like, oh, generally, and not focused on, in many but not all instances. They're trying to just not pay the bill. Remarkably, only after making written claims in May that compounded all of this did they individually go back and interview the filter team. And they admitted too, it would have been impossible to handle it appropriately. So they keep denying, they keep wanting to obstruct our ability to get our evidence. And so this is bad faith. And so accordingly, Trump submits this court should dismiss this superseding indictment and suppress all of the evidence that came from the raid at Mar-a-Lago based on the destruction of this very important exculpatory evidence and the bad faith the government has in keeping it hidden from the defense. Great filing, very thorough and enjoyable. Todd Blanche, Christopher Keese, the defense attorneys representing Trump there in the great state of Florida. And so we're going to be here continuing to cover this, my friends. A lot more litigation coming ahead. We'll see what Judge Cannon says about this as our coverage continues. We'd love it if you subscribe to our channel. If you haven't already done so, that would be amazing. And if you know anybody who might also have an interest in learning what's actually happening in these criminal prosecutions of Trump, we'd love it if you shared our channel and this video with them. We've got another great segment coming up where we're talking about Nancy Pelosi and a new J6 video. That's our next segment. We'll link you over there. We'll look forward to seeing you there and back here on the next one.